Good afternoon, everyone. It's dead on too, so hopefully everyone's joined us. Thank you so much for joining me this afternoon. My name is Gillian McAteer. I'm Head of Employment Law at Citation. And in this webinar this afternoon, I'm going to be looking at the 5 key things you can do to make a redundancy exercise a success. By success, I mean something which you should hopefully be able to defend should you ever land yourself in the very unhappy situation of facing an employment tribunal regarding that dismissal. Just a few things to mention before we start. First of all, and it seems very quiet, so I think everyone must have done this already, but if you haven't already done so, would you please put your microphone on mute? That's the button on the left-hand side of your control panel. It just makes things a lot easier for everyone on the webinar, and we have got quite a few people on the webinar this afternoon. And secondly, don't worry about taking notes as we go through, because a copy of these slides and a copy of the presentation itself will be sent through afterwards. So you can just relax and listen to what we're chatting through. And also we have scheduled in some time at the end for questions. So as we go through things, if there's any questions that occur to you, please pop them in the chat box. That's the, I think, third from the right, the little speech bubble icon in your control panel. And our host today, Dan Chapman, will pick those up and send them over to me at the end of my presentation. If you prefer to post your question anonymously, that's absolutely fine. Just post it directly to Dan as opposed to everyone, and he will read that out without mentioning who the question came from. So let's get started. Now, the first thing to bear in mind with redundancy, as with virtually everything in employment law, I find, but particularly so with redundancy, is getting yourself prepared before you actually start the exercise. And the foundation of this will be your business case and actually putting a business case together. I think sometimes when people think of business cases, they think of something that you've got to get consultants in, and it's all very complex and unnecessarily time consuming. But by business case, I simply mean putting down in writing what the challenges are the business is facing, perhaps what alternatives you've considered, things that you've tried to see if you can resolve the issue other ways, and then actually what it is you're having to propose to actually do. Which roles are you proposing to make redundant? Now, this is an incredibly important document, and as I say, it's not so much the amount of detail you go into or how complex it looks, but it's just actually instilling the bare facts in there. And that will mean that, first of all, it's very helpful in communicating to your employees exactly what the problem is and why you're suggesting redundancies as possibly the only way forward. Because obviously for most people, it's a very upsetting time and they're not really listening to what you say. So this is something that they can go away and look at and really understand why you're having to propose this. Secondly, as you go through the process itself, it's very easy to lose sight of why the company is doing this. Because people are very upset, they don't like selection criteria, they're really worried about losing their jobs. This helps you stay on track about why you're doing it in the first place. So it doesn't really matter how, how upset the employees are and how they don't feel it's fair, because you have got there why you're having to do it for business reasons. So unless anyone has got something which provides a solution to these problems, redundancy, unfortunately, will be the outcome. And then finally, of course, it's incredibly useful if you are ever challenged in tribunal, because it explains why you've taken this step. Now, so as I say, it doesn't have to be complex, but if it encapsulates the challenge that the business is facing, includes, and this was really good to show anything that you've thought of, a way that you can avoid it, and maybe things you've tried or ideas that you looked at but they wouldn't work for a particular reason, putting it in there, and then what you're proposing to do. That will be a fantastic foundation for actually moving on with the process. And when it comes to actually scrutinising a redundancy dismissal at tribunal, tribunals are not going to second guess the business decisions you make. You know, these are your businesses. You are going to be driven into acting in what is going to be in the best interest of that business. And a tribunal will not be looking at this and saying, well, actually, if we were running that business, I wouldn't have gone down the redundancy route now. I would have tried doing this, or I perhaps could have asked for a change in terms and conditions and looked at this and looked at that. You are very much still in control of business decisions. So really the focus is going to be much more on how you actually have handled the process. So it's not so much what you're doing, it's the way you go about doing it. Which brings me to the first thing that you will look at when you're making the actual redundancies themselves is identifying who you are going to be, consulting with. So if it's a standalone role, then that's very easy. It's just one person and you start the process with them. But what if you have got 10 people doing the same job in a department? That will be your pool of people that you're going to be selecting from. It may be that it's a little bit more complex than that, so that you may have a lot of people, for example, who work in an admin team. They all have slightly different roles, and actually you've decided that the best way of doing it now is to rationalize things and combine some roles together. But those people are doing work of a broadly similar type. And so therefore you might want to cast the net amongst all those people and include them in the pool and select from that. Again, actually, as an employer, you have got a very wide discretion in the pool that you're selecting, as long as someone can't say that you actually deliberately didn't include some people or included others because of some sort of discriminatory reason. The best advice I can give you is, if you are excluding someone or if you are including others, always be driven by what your business reason for it is, and always have that at the forefront of your mind. I would even make a note of those were the considerations you made, and this you chose that pool, because as I said, unless then there's something that's fundamentally unfair or discriminatory about it, if you've had a good business reason for doing it, you should be okay. Although what I would say is, and this would go for every bit of advice I give during this webinar, redundancies, it is a complex area, so it's always good to get specific advice on a case-by-case basis. And obviously, you'll hopefully, as Citation clients, you've got access to the employment advice team to help you with that. The third thing to think about, and again, this is before you have even spoken with the employees, is what your selection criteria is going to be. As I say, my experience, and I've been at Citation for 17 years now, and I was in private practice for 11 years before that, and I've always found it to be the case, if you get your ducks in a row before we start the process, it just makes things so much easier. So you think about what your selection criteria is going to be. This is an area that I think employers really struggle with, because how do you find a fair way of selecting from a group of people? So you've got 20 employees doing roughly the same job. What is the way in which you're going to select the 5 roles to be made redundant? Now, some roles really lend themselves quite easily to this task. So, for example, if it's a sales role, normally performance there is very objectively measured, because you'll have sales targets, you'll have conversions, things like that. So you'll have a wealth of data that you can help identify the selection criteria. But in others, it can be very, very difficult. The advice I would give is to try to keep it as objective as possible, because then if it's objective criteria, there should be some way to measure it so you can help justify what your scoring is. Because the last thing you want to do is get embroiled into the sort of debate about, well, you've given me a 3 for this, but I think I should get a 5. And actually, if I'd got a 5, that would have meant that I would have saved my job. So if you can make it as objective as possible, that's good. That's not to say, though, that you can't have subjective criteria. This is something which has been changing, I'd say, over the last few years. Increasingly, tribunals are recognising that as we've shifted more into employers recruiting for values and behaviours, and putting values and behaviours really at the core of what they look for in an employee, that is something that tribunals have been a bit more open to accepting, but there are some caveats to that. So for example, the ability to be a team player, work collaboratively, go above and beyond, all of those sorts of qualities. If you have them as built in as part of your appraisal or performance review process, and so you're used to discussing those issues with employees and you've got documentation there, the fact that they're subjective in themselves won't be a problem, because you will be, if you give someone a 3, you will have documentation on which you can base that. So it's not the easiest route, but it's not so. If you want to actually include some subjective criteria, if you have some sort of documentary evidence you can rely on to support your scoring, tribunals are more open to consider those to be fair criteria. And you do have to be very careful that you are not including anything which would be discriminatory. When it comes to selection criteria, I would say between 4 to 6 criteria is probably a good number. If you've only got a couple of criteria, then there's a lot of impact for each one of those criteria, so that can be quite problematic. And equally, if you've got too many, it just gets too complex. When you look at the criteria, you'll then also have to have a scoring guide. So again, and obviously the advice teams at Citation can help you with that. But it will be things such as, what does a 1 look like for this criteria? What does a 2 look like for this criteria? So there's real transparency. The more a tribunal can understand how you came to your decision, the more transparency you give to it, the much more likely they're going to consider that was done in a fair way. Now, at this stage, so you've gone through that process, you've mulled over what areas could potentially be problematic, but you're happy with what you're going forward. Now we move on to the absolute foundation of redundancy, and that is consultation with employees. Now, I've got to say, in my years of advising employers, normally when a client picks the phone up and says, I need to make a redundancy, this is not something that they've done lightly. I mention this all the time when I talk about redundancy, because normally it is something that they have been worried about. This is the last resort for them. They've racked their brains about anywhere that they can avoid the situation. So when I start talking about consultation and the fact that, look, when you speak to the employees, you must always talk about this as a proposal. Sometimes clients will say to me, that seems really unfair to me because I know there is no way we can avoid this situation. So I feel it's giving false hope. But there are no shortcuts with this, I'm afraid. If you make it appear that it is a done deal when you're going through consultation, that will fundamentally undermine your process, because consultation is such an important part, and for there to be proper consultation, you have got to be going through it with an open mind. So it's very, very important that you couch all your language in terms of what the proposal is, regardless of how much in your heart you may know this is absolutely inevitable. That's very important. We're talking here for the purposes of this presentation about a position where you're making less than 20 people redundant. If you're making less than 20 people redundant, then the law does not stipulate set consultation periods. It does if it's 20 and above. So if it's 20 to 99, you have got a minimum consultation period of 30 days. And if it's 100 or more, you've got a minimum consultation period of 45 days. And also, as part and parcel of those collective consultation obligations, you have got, obligations to, consult through reps and have election of reps, and you've got to provide statutory information before that consultation can start. And it is very important you get that right and you think about this right from the very beginning, because obviously the timing will be important. So if you are looking at 20 and above being affected by it, then absolutely you really need to be taking advice as soon as possible. You'll have to fill in an HR1 form. And if you fail to meet your collective consultation obligations, each affected employee is entitled to bring a claim for a protective award, which will be 90 days pay, and there is no service requirement for that. So if you that's really probably the remit of a different presentation, but be aware if you're talking about those numbers. If it's under 20, there's no requirement to consult for a minimum period of time, but it's got to be meaningful and full. Now, I don't think that you can really do that in less than 2 weeks. I certainly think it would be very challenging to do that in less than 2 weeks at the moment, when people may be furloughed or working from home, and they're not as accessible as they are. There is a big gap between making 1 or 2 people redundant and making 18, 19 people redundant. So actually, if you're making 19 people redundant, what looks like fair and reasonable may be veering towards the 30 days. So actually take that as your byword, that it's going to be what's fair and reasonable, and work from there. You consult with them, all the affected employees. You consult on every aspect of it. So it's consulting on the proposal to make them redundant. What suggestions do they have of any alternatives? What suggestions may they have of any alternative positions, roles within the business, and also, of course, consultation on the selection criteria. Now, this is not agreement. I think it's very important to stress that this is not about getting employees to agree to what you're saying, because especially with the consultation on selection criteria, there's always going to be winners or losers. It's very difficult that you can get everyone to agree with everything, but it's taking on board what they say, and then really, sort of bearing that in mind and making sure that you're still happy with what you've got, or changing it accordingly. Final thing to bear in mind, and this is something which is often neglected, and that is that it is an obligation on your part, and it's one of the pillars of establishing a fair redundancy process, that you have advised people of alternative vacancies. And that's throughout the process. And that is the best advice I can give in relation to that is just share all vacancies. I've seen so many clients over time deciding, well, I didn't tell them about that particular position because I didn't think that they would be qualified for it. Once you start making those assumptions, and there's been some, very high profile cases in the past where there have been very, very high awards of damages, you run into all sorts of difficulties. So make them aware of everything. Don't make judgments about what might be suitable for them. Obviously, you don't have to offer them those roles. And if there are different roles, they would have to apply just like everyone else. But so be open and always keep an eye out for roles. And I would advise dealing with that at every consultation meeting, is circulating a list of vacancies if you've got them, and continuing that all the way through to the dismissal meeting. Be aware also that there is special protection for those who are on maternity leave. So for those who are on maternity leave, if an alternative, so they have to be, first of all, selected for redundancy. So just because they're being consulted on redundancy doesn't mean that they need to get that role. But if they are selected for redundancy when they're on maternity leave, then if there is an alternative role which they could do, they get priority above other candidates. That's where the special protection kicks in. Just a couple of questions that have popped up recently about the interrelationship of with the redundancy and the furlough scheme. Can I still make redundancies if the furlough scheme is available? Well, absolutely yes, because just because there is the furlough scheme available, it has been, questioned, are employees going to be able to say, well, you shouldn't have made me redundant, you should put me on furlough? We don't think that there is going to be any merit to that argument, because quite apart from the fact that from next month there's going to be a financial element to furlough for employers, but even before then, you are still accruing potential liabilities with employees because they're continuing to accrue holidays, etc., and perhaps kicking over into additional years of service, which will affect what their entitlements are. So if you think the right thing for your business is to make a redundancy, the existence of the furlough scheme should not make that decision unfair. Can I still claim furlough subsidy for employees during their notice period? Well, if you'd asked me this last week, my answer would have been the same as it has been ever since we first saw the scheme rules, which is there's nothing to stop you from claiming the furlough subsidy during an employee's notice, as long as you have kept the employee in the books. So if you've paid them in lieu of notice, then they're no longer your employee anymore, so you wouldn't be able to claim the subsidy. But say, for example, you've got someone who is entitled to 4 weeks' notice of redundancy, you could keep them on the books and apply for that furlough subsidy during those 4 weeks. That has always been the position as we understood it. In terms of the employee guidance on the furlough scheme, it says your employer can make you redundant when you're on furlough. The only reference in the employer's guide is the fact that you can't use furlough subsidy as a substitute for the redundancy payment. But that's completely different from notice. The redundancy payment is calculated differently. So, when there's not anything that says you can't do it, everyone thought you could do it. And it may be that you can still do it. But I do want to highlight that when the Treasury issued a third direction late on Friday night. Now, the Treasury direction is the legal framework for the furlough scheme. The employer's guidance and the employee guidance is how HMRC translates that and explains to businesses and employees how it works. But the legal framework is in the Treasury direction, and they are very dry and tedious documents, as you can imagine. So they issued a third one late on Friday to take into account the flexible furlough scheme. And they added some wording, which I'm actually just going to read to you because we don't know how significant it's going to be. There's always been a clause in the direction which has said what the purpose of the scheme is, but they have changed it. So it now reads, integral to the purpose of the CJRS is that amounts paid to an employer pursuant to a CJRS claim are used by the employer to continue the employment of the employees in respect of whom the CJRS claim is made. Now, that definitely casts a question mark about the ability, whether it is correct to claim furlough subsidy during a notice period, because could those monies be said to be truly used by you as an employer to continue their employment? Now, there is an argument to say that, well, while they're serving their notice, their employment is continuing, so it does cover it. But it's a question of, well, do they mean continue their employment in the wider sense of keep them employed? Or is it just in the sense of, yes, they are going to be with you for another few weeks? They updated the employers and employees guidance yesterday morning, again, to just clarify a few things, in particular the use of holidays and how holidays should be treated for flexible furlough pay calculations. But they haven't changed, they haven't put anything in there about redundancy. So my advice would be, this now does put a question mark over it, but it certainly doesn't say for certain that you can't claim it. So you've got a choice if you do find yourself in this situation, either make the claim and wait to see whether or not that's proved to be something you shouldn't have done in a subsequent audit. Although I've got to say, I certainly don't think there'll be anything fraudulent about that. It's just you've made a mistake, because it absolutely is not clear, and there's nothing in the employer's guidance which says you shouldn't do it. If you wanted to be on the safe side, you could contact HMRC in advance and say, am I entitled to make a claim for that? I think many businesses at the moment, because of the fact that they're struggling even to make redundancy payments, are out of necessity saying, well, unless I'm told I absolutely can't do, I'm going to make the claim, and then I'll wait and see what the guidance clarifies. And in terms of the notice pay, although you can recover the 80% at the moment, obviously in September that's going to be changing slightly. In most circumstances, you are going to have to top that up to normal pay, because there is a protection. There's some complex rules where there may be exceptions to that, but generally, by and large, you are going to top that up and add the additional 20% to notice pay. So just before we head off to questions, I just want to remind everyone we're really busy at the moment with obviously all the redundancy support we're giving to clients, and about a fifth of all the advice we're giving to clients at the minute is helping them with the redundancy processes. And that includes, a lot of clients want us to actually, be there and do meetings with them and, really help them all the way from, the announcement meeting all the way through to dismissal. So that's something that our on-site HR service can help with. Most of these meetings are now happening remotely, of course, because of the circumstances. But clients do like to have us there actually helping them, because it is such a stressful situation for them. But also we have got strategic on-site services as well. If you're faced with, as many clients are, a number of options, and you don't know whether it's going to be best for the business, if you're looking at maybe changing some terms and conditions rather than a wholesale redundancy program or a restructure, so we can get involved right at the very beginning for the on-site service. So hopefully, Dan, we've got some questions here. I've just seen, I'm sorry to grab that one, but Cynthia's question just popped up as I said, Dan, have we got any questions? She was asking whether we have any selection criteria we have as an example. The advice team does have an example selection criteria, a template. I'm wondering, to make things easier for people, would it be possible, Dan, that if I shared that with you, you could send that out in the email together with the coding? Yeah. Slides. Well, fantastic. I'll do that then. I'll make sure that's done. Bear in mind, of course, it's just a template, and therefore it's always better when you're actually going through the process to get advice, so you can make sure that the advice is tailored to your individual situation. Perfect. Great. Thank you.
Thank you everyone for your questions so far. If anyone has any questions, please feel free to pop them into the chat box as well. We'll get to as many as we can. The first question, Jill, is Daryl, who asks, could we ask staff for voluntary redundancies at the beginning of the process?
Yes, now that's a really excellent question, and I'm always a little bit wary about the whole position with regard to voluntary redundancies. Or asking people to volunteer. In a textbook redundancy exercise, that's one of the first things you'll be covering at the beginning. I think it's probably just years of experience that makes me a little bit wary of it. But in a, textbook advice would be absolutely ask that at the beginning. And normally, when you ask volunteers as a business, you do have the right to say no. And I've just had so many experiences over the years where the people who volunteer for redundancy are the best people. They're the people that the business doesn't want to lose, or they're the people who are going to be most expensive to get rid of, because they've got 25 years service and they're going to have a massive redundancy payout, so they don't want to accept them. So either they're then put in that invidious position of either we accept them, but actually it's not what the business wants, or they do what they can do and say, well, thank you for applying for volunteering, but actually we're not going to accept that, in which case that leaves a nasty taste in the mouth of that employee and all other employees in the pool. So it's definitely best practice to ask for that, But if you are concerned because of the people in the pool, that there's a good chance you might have people volunteering who you are not going to want to accept. And with all the, I mean, it's not illegal obstacles, because as I say, you can say no, but it just makes things that much difficult later down the line. So bear that in mind. If you don't mind who goes, it's a great thing to do at the beginning, because then hopefully it might take the decision out of your hands.
Perfect, great. Thank you, Jill. Question is from Patty3 is the username, and the question is: we have put 2 people back in the payroll because of furlough. When will their last day on the payroll or the notice period be?
Sorry, could you repeat that again?
Of course. So the question is: we have put 2 people back in the payroll because of furlough.
But back on the payroll. Oh, so there were no. So you had dismissed them and you put them back on the payroll because of furlough. Yes,
I think so. Yes.
And when will their last day of employment be? Was it?
When will their last day be on the payroll or of their notice period?
Well, so I may have misunderstood the question, and if that's the case, perhaps the person who's asked it can put some more information. But if this is a situation where maybe, and in the heady days of the first few weeks of the scheme, Martin Lewis was my nemesis, because he was telling everybody everywhere, you should re-employ people who have either just left you or you've just dismissed, because actually they won't be able to get furlough with any other employer, and it's only fair to do it. And I was repeatedly saying, no, but you've got to think that if you bring them back, you are re-employing them, and then they remain your employee, because you've got the furlough scheme here, which is effectively just a treasury funding scheme, and you've got employment. And when you put people back on the payroll, you are effectively re-employing them. So now, if it was a situation, and as I say, maybe I've misunderstood the question, but if you took someone back just for the purposes of being able to give them access to furlough pay, you now need to terminate their employment. And I suppose a lot will depend upon the basis on which you took them back. So I think there were many employers who felt that, this was something that morally they had to do. And now chickens are coming home to roost, and they're actually thinking, well, I don't need these employees. So I need to, we need to part ways now. And how you do that will very much depend on, what the gap was in their employment, what you told them when you took them back. So that's definitely something I would speak to the advice team about.
Perfect. Thanks, Jill. Hopefully that answered your question. If it didn't, please let me know. Perfect. Next question is: I have to make 4 people in a team of 10 redundant, but 2 of those are on maternity leave. Do I include them in the consultation?
Yes, you absolutely do. There's no problem with consulting with people when they're when they're on maternity leave. You just have to make sure that in your selection criteria, you do not discriminate against them. And actually, that can mean being overly favourable to them. There's a leading case on this, which actually involved a discrimination brought by a man. Basically, it was actually a case brought against one of the country's leading firms of solicitors, which just shows to show you that everyone can fall foul of the complexities of redundancy. And what they'd done in that particular case was this was a fee earner, and they measured the time between a case being completed to the time the person the bill was paid, and people were targeted about getting their bills out and getting their bills paid on time. And they had some word as to what they called that period of time. And what they did was that was one of their key criteria in deciding who they were going to make redundant, the person who scored least at bottom on that. And because they thought, oh, we don't want to discriminate against this particular employee because she's on maternity leave. And what they did was they gave her top marks for that criteria. and which meant that she came above a guy who worked in the same team, and he brought a claim for discrimination on the basis that that had been unfair to him, and he was successful in establishing this was unfair. What they should have done in retrospect is to say, because it's all about really not giving the person on maternity leave an advantage, but leveling the playing field. So what they could have done is look to a period for her, which was, say, for example, they were looking at a 3-month period. Look at the period 3 months before she started maternity leave to see what, on average, her performance was like, rather than giving her top marks. So yes, absolutely consult, but just be wary of either sort of doing something which puts her at a detriment in terms of your criteria, or inadvertently puts her in a better position, which may then be unfair to other people.
Great. Thank you, Jill. The next question is from... Ooh, go on.
Sorry, Dan, I'm terrible
Okay.
like this. I see a question and I grab. I'm just jump on it. So I think it was Jerry who was asking a question about, do we share the scores? I don't know whether you see that one, Dan.
Yes, just come in, yep.
Yeah. With that, yes, you should, as part of, so basically as part of the consultation, you'll move from the group consultation when you're dealing with everyone as a group, and then you will move into the individual meetings. There's normally 2 individual meetings. The first individual meeting is when you share the score with people, and what I would advise doing is you're not just going to give them their score. It's a good idea to actually show where they came in the scoring, but blank out everyone else's name, so they can see what they scored in each criteria, and they can see where they fell within the other criteria, but not reveal everyone else's names. So that's the ideal way of doing it. I'm sorry, Dan, I will not jump in again. That's why I tried to learn tango dancing. I was always wanting to lead, so.
Don't you worry. The next question is from Suzette, who says that they have notified a fellow member of staff that they are at risk, but they have been unable to get hold of this person via calls or via email. If they did not contact us, can we continue through with the process and send them a letter?
That's a really good question. I think in these unusual circumstances, you would really have to go above and beyond to show that you had absolutely tried to contact them, by any means you can. So I don't know what their personal circumstances would be. Maybe, we've got a lot of employees, for example, who are not UK nationals, who have actually gone abroad. When I was in this morning, went home to Germany. So if you've got email addresses, really be seen to be trying to make sure that you've done everything you can. Ultimately, if you have got every reason to feel that they're getting your communications but not responding to them, they can't hold the process up. Of course, you can go ahead with it, but if they suddenly pop up out of the woodwork in the future and say, this is really unfair, you didn't consult with me at all, you really want to be able to have, some sort of like audit trail that you did everything you could, that was reasonably possible to consult with them.
Perfect. Great stuff. Thank you. Next question is, if there is a change in circumstances after I've made somebody redundant and I need to recruit someone for that role, how do I kind of do that? Is there anything that would stop from having an issue with that?
Well, I think the point at which your decision to make someone redundant is going to be judged is the facts that were prevailing at that time. So if you make someone redundant in good faith, and then 3 weeks later you win a big contract, or one of your competitors goes bust, and you get a lot of work from that, then that's clear change in circumstances, so that it wouldn't make it an unfair dismissal. Where you would potentially have a problem is, a lot of businesses really, and I'll be absolutely honest, use situations like this to think, well, you know what, this person was always a pain and I'm doing other redundancies, so let's just get rid of them now and then, let the dust settle, and in, a few weeks I'll bring someone else in. And that's when definitely it would be problematic. Certainly within the first 3 months is going to be very, very problematic. So if you do need to recruit afterwards, the key thing to think of is, can you show what the intervening event was, which meant that you needed to find someone to do that work when you made someone redundant because you didn't need someone to do that work.
Perfect, great stuff. Thank you, Jill. The next question is from Julie, who was asked if you could clarify whether if someone's given notice of redundancy but they're on furlough, do they need to top up the salary to 100% for the notice period?
Right, so the rules are, generally speaking, I'm getting my pen out now because it is very complex. Generally speaking, when someone is serving notice of termination of employment for whatever reason, the law provides that they have a right to their normal pay for the statutory notice period, even where, for example, they're off sick, they're on maternity leave, and the other criteria is if they're available to work, but you're saying there's no work available. And that's just a protection to pay during notice. It's provisions of the Employment Rights Act. Now, obviously, people on furlough would fall into the category of people who are protected, whose notice is protected at full pay during their statutory notice period. Now, there is an exception to this, and the exception is where you as an employer, when you're giving them notice now, the contractual notice you need to give them is at least a week more than their statutory notice. And in that case, I think of it as kind of like a little reward for being generous in your contractual terms. That right doesn't apply. So if we looked at a situation where someone has been with you for 2 years and you have got a clause in your contract that, at that point of service, you're going to give them a month's notice. So because they're only entitled by law to 2 weeks notice, and under your contract, you're giving them 4 weeks notice, they don't have that right to full pay protection. So you could pay them the 80% during their notice, subject, of course, to the fact that we've got now this question mark about whether you could make the furlough claim in the first place. But let's leave that to one side. So that's the general rule. There is a right to protection of full pay, which means you've got to pay 100% unless you have got these more generous contract terms, in which case that right to protection doesn't apply. But bear in mind, of course, that this is a movable feast as well, because it depends upon the time at which you make them redundant and you're giving them notice of dismissal, because it's very common for clients to have in their contracts to say, right, well, for the first, up until the 5th year of employment, after the passive probation period, I'm going to give a month's notice. And then after that, we'll go to statutory. So under 5 years service, they get a month's notice. Once they've hit 5 years service, it'll go 5, 6, 7, etc. So if you were making that person redundant at year 2, then those are more generous terms. But of course, by the time if they had 6 years service, it wouldn't be more generous, because actually you're only then giving them exactly what they would get under the law. So they would have the right to full protection then. So I'm sorry, it's really difficult to explain that in a really short and pithy way, but that is the legal position.
Perfect, great stuff. Thanks, Jill. I'm just conscious of the time. My apologies. Hopefully, we've got time for a couple more questions. questions.
One.
First question is from Becky, who asks, are employees who are on maternity leave protected from redundancy during their statutory leave and for 6 months once they return to work?
So it's definitely during the statutory leave. The 6 months, I think the 6 months, that is not law at the minute, as far as I know. That was one of the changes. I mean, the government had a whole host of changes they were going to be introducing and giving individuals extra protection, including when they came back. And I think the proposal was that special protection that they've got during maternity leave would be extended to 6 months on the return. But I don't think that's been put into law yet. And goodness knows when that will actually be put into law, because we were supposed to have a new employment bill. It will be some time, I think, before we get back to the ordinary processes of employment law. Is that, do you think that's it? We have run over a little bit.
Yeah, there are still a few more questions, but for anyone that has left a question, we haven't managed to get a chance to answer that question during the session, we will be replying to each of you. So if you'd like to just drop me a message just with your email address as well, then we'll make sure that all those questions are answered after the session as well. Thank you.
Thank you so much for joining me this afternoon. Hope you found it useful. If you do have any HR employment questions, you have got details of our advice line there. You should have obviously your cards as well. And I think if you're interested in any of the additional support we can give through redundancies or indeed strategic reviews of restructuring your business, etc., then the details are on the screen. And I believe, Dan, are you able to drop those into the web chat as well for people to access? Okay, fantastic. Thank you so much for joining me, everyone, and good luck with your business. Bye-bye.